Chris, can you hear us?
Yes, I hear you very well. Thank you, Minh.
Oh, terrific, terrific. Now we just need to see you.
Okay.
Now we see you.
Great. Thank you very much.
That's
A
perfect.
pleasure to be here. Thank you.
Okay, everybody, let's get rolling. We're fashionably late, but like airplanes, maybe we'll catch up sometime as we go along. First of all, thank you very much for attending this book launch on behalf of YKVN, SCLVN, and Kluwer's. We are delighted to have with us Chris Seppälä, who is of course, as we all know, a leading authority on FIDIC contracts. All of you have heard his presentation yesterday. So I thought that what I would do to start off this session is to perhaps set the stage for the discussion by talking briefly about my own experience with Chris's book. About a year and a half, maybe 2 years ago, we were researching the question of liquidated damages or delay damages and how they should be treated under Vietnamese law in the context of FIDIC contracts. We came across Chris's book at some point and found that it was tremendously helpful in providing the kind of broad perspective that, frankly, we are missing in Vietnam. I reached out to Chris, who happened to be, he and I were partners of the same firm many years ago. I also knew him for many years back. And Chris very graciously provided the answer to my questions. Later on, he invited me to participate in the book launch in Singapore, at the end of which I made the pitch to him that I thought Vietnam was a hot market in this region for his book because of the way in which we have been using FIDIC contracts. Now, why are we using FIDIC contracts? Because we're required to use FIDIC contract as a matter of law. And who requires us to do that? Well, the ODA providers, for one, who are the principal financing source for Vietnamese infrastructure projects, have made it quite clear, jointly and severally, I might add, jointly, by that meaning the World Bank, the ADB, the IMF, KfW, JICA, the Korean development. They all want to see Vietnamese projects being undertaken using FIDIC contracts. Because of that agreement between them and the government of Vietnam, the use of FIDIC contracts becomes a matter of treaty law, which under Vietnamese constitutional principles are the supreme law of the land. And in fact, in every Vietnamese statute and regulation, you will find a clause that says that if a treaty of Vietnam provides otherwise, then you just close your eyes and apply the provisions of the treaty and don't worry about the inconsistent Vietnamese statute. So we are now in a position where we have these FIDIC contracts that are mandated for use in Vietnam in Vietnamese projects. And then we have the existing Vietnamese legal framework. And the question then becomes, well, how do you reconcile the two? And in my mind, the task before us is one of harmonizing FIDIC contract principles with existing Vietnamese legal principles. And this is not something that will occur overnight because we're not, the lawyers are not, the parties are not the people who are the key decision makers. The people who are the key decision makers are the Vietnamese judges and perhaps international arbitral panels to the extent that they render opinions in awards in complex cases that are subsequently published. And so in each of these proceedings, questions will come up, and questions will come up that will lead people to wonder what should be the appropriate Vietnamese legal principle to be applied. And I suspect that the answer will depend, first of all, upon the facts, secondly, upon the quality of counsel or the experts in terms of arguing one viewpoint or the other. But it's going to be a piecemeal process, which is not that different from the common law process of developing law through cases. That being the case, it's clear to me that having access to a book like Chris's book as a reference work, which will suggest answers based upon international experience and perspective, is going to be a tremendously helpful tool. And of course, if we're lucky enough to have Chris's advice on a particular case, that's even better. So what we thought we'd do today, since Chris has already talked about some of these principles in his presentation, we thought we'd start the dialogue with providing a Vietnamese counterpoint to the three topics that he touched upon. And they are the role of the engineer, the role of dispute boards, and the limitation of liability in FIDIC contracts. We are very privileged to have a very distinguished panel to present the Vietnamese counterpoint. To my left is Mr. Trung, who is the chair of SCLVN, perhaps one of Vietnam's foremost experts in FIDIC contracts. As an engineer by background, but as we all know, FIDIC contracts were written by engineers, and a lot of lawyers suspect for engineers. Next to him is Dr. Hoa, who teaches international arbitration at Ho Chi Minh City Law University. And she happened to have done her thesis at Paris 2 in principle on dispute resolution procedure in international construction applying FIDIC forms of contracts. So she's just the perfect person to tell us, to provide the Vietnamese perspective on dispute boards. And finally, over there is my partner, Nguyen, who will be addressing the question of limitations of liability in FIDIC contract. In terms of format, what we thought we'd do is, after each of our Vietnamese speaker gives their perspective on the question at hand, then Chris can chime in and give his perspective. What we would like to do also is to make this session as interactive as possible and to invite lots of questions. So whatever time is left at the end of the initial discussion will go fully into the Q&As. And to the extent any of you have had questions left over from yesterday or new questions, we would welcome all of them. Today is a slight improvement on yesterday in the sense that Chris is able to see the room today, and he will be able to see the person asking the question. So hopefully that will make for a more meaningful dialogue. One last point, if you want to ask your question in Vietnamese, please do so. One of us up here will try and quickly translate it. No promises made about quality. So with that, and without further ado, let me turn the floor over to my friend, Mr. Trung. So Mr. Trung, tell us about what the role of the engineers are in a FIDIC project in Vietnam.
Yes, thank you, Mr. Minh. I'm civil engineering background, and also like many people within FIDIC, we have the engineering background, especially the one who drafting FIDIC Red Book, Emerald Book or something. When I met them, I also asked about how they prepare the contract, and they often mention Christopher Seppälä as the one legal advisor for the FIDIC Contract Committee who always provide very good advice to him. Come back to the question regarding the role of the engineer. In FIDIC contract, you will see the engineer. It be translated into Vietnamese sometimes as the consultant or something. But coming to Vietnam law, in Vietnam law, per construction law of Vietnam, they know the engineer similarly. We only have by project. For each project, there will be a separate title. For example, during the design engineering, they will have the survey engineer. They will have survey consultant and design consultant, and also feasibility study consultant. And for the one who review, appraise those documents, also they have the design review consultant, feasibility study review consultant. Those kind of things going through the process. When they come to the construction stage, they will have the supervision engineer. In Vietnam, they want a title that often be equivalent to the engineer. It is called the project management consultant. However, in the construction law, the project management consultant also equal to project management board. And if a project have the project management board or project management unit, then it's not possible for you to also hire a project management consultant. So in this case, it's for a metro project in Vietnam where we have also the PMU, PMB, if some way, somehow cannot use the project management consultant anymore. So from that point, it's quite be hard to bring the role, the engineer into our law or to match with the current construction law. Yes, that's just a comparison. So on the paper, especially in one project in Hanoi, even the employer complained about FIDIC contract. Why FIDIC gives so much power to the engineer? That power should belong to the PMU, project management unit. The engineer should be only the supervision only. It's not suitable for our construction law. That is some view. So I remember that in the book of Chris that mentioned and also available outside, he in the view of numerous duties assigned to the engineer by condition, a Red Book contract cannot be performed without the engineer. So in that case, you have to rewrite and prepare separate space for the engineer in your contract to match with the FIDIC one. Just my point. Chris, do you have something?
Yeah. Yes. Thank you very much, Trung, for that. Let me first of all thank very much Minh and his law firm for organizing this event. I'm really very flattered that they should do that for me and for my book, and I'm very, very grateful to them, and I'm very grateful for all of you to attend this event and to discuss this very interesting topic, which is obviously tremendously important in Vietnam, as Minh has explained, because Vietnam has its own traditions, civil law tradition, its own culture, and then trying to fit the FIDIC contracts into that culture is obviously a huge challenge. I understand that. Let me just, if I may, just repeat what I said yesterday, if I may, just on this point of history. if you go, because the FIDIC contracts have adopted the English civil engineering tradition, which is totally different from the French civil engineering tradition. And to go back as to why, and the main difference being that the engineer has various independent powers under the contract, or as Trung was saying, maybe he has too much power, and that when the first edition of the FIDIC contract was adopted published in 1957, a decision had to be made as to, well, what traditions should be incorporated in the FIDIC contracts. And apparently, under the pressure of the World Bank at that time, they decided to adopt the English tradition of the independent engineer rather than the French tradition, where there is no independent engineer. And I can only speculate why they did that, but I think there were two reasons perhaps for that. The first is that the FIDIC contracts are for use in developing countries, and I think the feeling in the bank may have been that in some developing countries, there will not be, the local officials may not have the skill and the experience to manage big construction projects. Therefore, it'd be good for there to be an independent engineer who would manage those projects and, for example, evaluate claims, assist in the resolution of disputes, evaluate work, and certify payment, determine what payment should be made to the contractor. And I'd say the second reason may have been because corruption is more of a problem in the developing world than it is in the developed world, although it's of course a corruption it's a problem everywhere. But I think the feeling may have been that an independent engineer could assist the bank in ensuring that the public money that the bank is making available is properly spent on the project and is not diverted to, or misused. So those are the two reasons I suggest briefly why we have the independent engineer. And I won't say more unless there's a specific question.
I have just one very quick follow-up question. I must say that listening to Trung and to Chris, I am thoroughly confused about who this engineer is supposed to work for. Whose interest is he defending? Because understanding his motivation must be, at least for people on the contractor side or even on the owner side, a very key factor in how they shape their participation in the project.
Well, if I could just respond to that. When we're talking about an independent engineer, what I mean is that the engineer has certain powers under the contract, as I was saying, to evaluate work and to determine what payments are due to the contractor, and is bound to do that in a fair and neutral way, not acting solely in the interests of the employer who has engaged and who pays him, but in the interest really of when you say of the project, in the interest of both parties. That is whom the engineer should be acting in the interest of. And therefore making determinations about what money is due to the contractor, doing that in a fair and neutral way. Of course, doing that under, if either party objects and feels that the engineer has not acted appropriately, of course, that can be appealed to a dispute board. And the dispute board is totally independent body, and they can correct that, or to arbitration, which is also a totally independent body.
Thank you, Chris. That is the perfect segue into the next presentation, Dr. Hoa. So now we have an engineer that somebody in this process has thought is neither fair nor independent. So now we head into the dispute board, and let me invite Dr. Hoa to give us the Vietnamese perspective on dispute board.
Thank you so much, Mr. Minh, for your presentation and for your introduction. And first of all, I would like to express my special thanks to YKVN and also thanks organizer for giving me this opportunity to share some researching about dispute board. Regarding this procedure, in 2012, when I was legal expert at the Department of Justice of Ho Chi Minh City, I had the opportunity to deal with a case in which pupil committee of Ho Chi Minh City, to which the pupil committee of Ho Chi Minh City was party, and in this case, though both parties have used the Red Book 1999, and there were also a clause on dispute board. And at that moment, the expert in Department of Justice like me, we don't well understand what does it mean DAB and what is his role, because when I read the Red Book, I understand that DAB have also the discretionary power to render a decision. So I think this power exists only in arbitration procedure for the arbitral tribunal. So at that moment, I don't well understand. This is the reason why I was sent by the committee to Paris to study FIDIC form contract and dispute resolution procedure in this sector. And this is the reason why I have to say that I'm a fan of Chris' writing, because I study a lot of his writing on dispute board and on FIDIC contracts. And up to 2015, I see in a resolution of Vietnamese government Vietnamese Minister of Conjunction to say that there will be a procedure in Vietnam. There will be a procedure for public projects called Dispute Resolution Board. But in this provision, say that in case of when the DB, I can call this DB, when DB ran a decision, if both party don't object it's become binding both party. So in this kind, I understand that under Vietnamese law, DB like I do a comparison to a mediation procedure, because it is necessary to have the agreement of the parties so that DB decision can be enforceable. Whereas according to FIDIC form contract, I understand that once DB give a decision, the party have respected and executed immediately. Even there is a claim before the arbitral tribunal, but during that time the party have respected. But I think this mechanism would be difficult to be executed in Vietnam, because, for example, regarding our law, Vietnamese law, we don't have this mechanism. For example, I understand if there is the case that one party does not reject DB decision, but also they don't execute it. For example, if this is the decision to obligate one party to pay for other, in this case, if they don't, for example, the employer does not pay for contractor, we don't have a mechanism to enforce it. Regarding arbitration procedure, under Vietnamese law, it's true that the arbitral tribunal have the power to order a provisional emergency measure relating to payment. But if this is a international dispute, there is an international dispute, we have order from foreign arbitral tribunal, in this case, Vietnam is also member of New York Convention, 1955, but the New York Convention does not define what does it mean, the award. And under Vietnamese law, Vietnamese arbitration law, we just recognize one kind of award is a final award. This means that if the arbitral tribunal made a decision or pass your word or an provisional emergency order, it could not be recognized according to New York Convention in Vietnam. This is the case in our countries. So, to be honest, personally, I think the DB procedure is not bad at all if we regard the part, how to say, the disadvantage of this procedure, because DB is constituted by the expert who follow the project from the beginning. So they will well understand what happened during the project. So I think they will have the most correct vision firstly. So if we can develop this mechanism and take advantage of it, I think this could really useful for the parties to avoid a arbitration procedure which is really expensive. I believe that. So this is the reason why I would like to hear some point of view from Chris. So how we can develop this mechanism in Vietnam regarding to the legal issue that we are facing with.
Yeah, Dr. Hoa, thank you very much. I think that's everything you said is very, very interesting. Let me say, you do have in Vietnamese law, of course, the principle in your civil code of freedom of contract. Parties are free to write their contract in the way they please, obviously in compliance with the law, but the basic principle of freedom of contract. And I think it's proper to think of the rules governing the dispute board as being giving effect to that freedom, and thus when the contract says that a dispute board decision is binding, even if one party expresses dissatisfaction with the decision, but it must still be respected, that is doing no more than requiring the parties to respect their obligation, which they have agreed that the decision be binding, that they will respect it. So it's nothing more than exercise of the freedom of contract to require that they observe the decision, even if it has been objected to by one of the parties. On the question of partial award, you were saying that a partial award in Vietnam would not be enforceable under Vietnamese law, or not recognized. Not recognized. I think in that case, I mean, the solution under Vietnamese law is therefore to begin a separate arbitration for each decision of the dispute board that you need to enforce, so that you will have a final award on that issue. That's obviously a bit more expensive and a bit more complicated, but that's the lesson is, as partial awards cannot be enforced, to enforce dispute board decisions, then you have to begin a separate arbitration for each decision. That seems to be the point. I think there was something else I wanted to add, but I'm just, if you could remind me, Dr. Hoa, of what I've not said, because of what I've not dealt with, then I will be happy to deal with it. So
it's okay. I just have a comment on your comment that you say that because according to Civil Code of Vietnam, we have well provided that there is a autonomy of party, and the party have to respect their something they have promised. It's true. It's true. This means that, and so I understand that to enforce a DB decision, it depends on a lot on the good faith of the party. So the problem we have to resolve is, in case there is not a good faith from one party. So this could be the case. So if everyone react in a good faith way, I think it could be better. So the problem is, in case that the good faith do not respect it, is not respected, what will be?
Dr. Ho, let me. Of course, when we're talking about the dispute board, we're talking about an ADR procedure, an alternative dispute resolution procedure, and these types of procedure are dependent upon the cooperation of the parties. Parties need to agree that this is in their mutual interest to respect this procedure. And if one party doesn't play the game, well, then yes, you're probably better off going directly to arbitration. But let me just emphasize, and this was something I wanted to begin by emphasizing, why do we have a dispute board? Remember, we have the dispute board under FIDIC contracts or under common law construction contracts is basically because the dispute board replaces the engineer as a decision maker, as a decision maker under the contract. And the dispute board is, of course, as we've seen, is an entirely independent body, unlike the engineer. But what is the purpose of these procedures? Why do we require the parties to comply with a binding decision, even if one party objects to it? Remember, the whole purpose of this procedure is to ensure that the contractor gets the appropriate cash flow to continue building the project. Remember, and this is something that I think some judges in some courts, when they've been interpreting dispute board provisions, have not been aware of or have not been neglected. And that is, the contractor, when he undertakes a construction project, he undertakes to work without stopping. And yet the principle is that the employer should be providing the cash for the contractor to build the project. But if the employer is not doing so because he's not complying with an independent dispute resolution procedure under the contract, that is a problem. And remember that both the contractor and the employer, when they agree to the dispute board, they each accept the risk that the dispute board's decision may be wrong. It may be wrong against the employer, it may be wrong against the contractor, but they agree to comply with it. And that's the counterpart, if you like, of the fact that the contractor is committed to work without stopping. You can't expect the contractor to commit without stopping unless the employer is complying with the procedure that they have agreed should deal on an interim basis with disputes that arise under the contract, to ensure that the contractor receives reasonable cash flow so it can continue to build the project, because the contractor is not expected to finance the project. So all of this interim procedure is just to ensure reasonable cash flow to the contractor. The contractor, of course, takes the risk that the dispute board may rule against him, and yet the contractor has to keep working. The contractor cannot use that as an excuse to stop working. But the contractor, of course, gets the benefit of decisions that are rendered by the board in its favor and against the employer. But that's a risk both parties take of, the decision of the dispute board may be wrong. Their remedy then is to take the matter to international arbitration. But in the meantime, both have agreed they must comply with the contract, again, fundamentally because the contractor is not allowed to stop work, because we all know if the work stops, the costs for everyone may be much higher even than what is involved in the particular dispute.
Go ahead.
So thank you so much, Chris. So I think regarding your comment, I understand that DAB is really useful for a contractor. So if you are a contractor, try to convince Vietnamese government to recognize this mechanism so that you can have the mechanism to protect yourselves. It is just my small point of view from my
Well, if I
side.
could,
Doc-
if I could
Doc-
jump in
Dr.
here.
Ho, on the question of getting the government to accept the idea of a dispute board, let me just say is the World Bank and the big the big multilateral development banks, they are mainly concerned with the interest of employers under construction projects, because that's who is borrowing the money from them, and that's from whom they expect to be repaid. And the World Bank mandates the use of dispute boards in major projects that it finances. So I'm just saying that should be a rather strong argument for any employer who's considering whether or not to introduce the dispute board. Sorry, Minh, I interrupted you.
No problem. I was going to ask a follow-up question along the same lines anyway. So if I could just back up, what I'm hearing is from Dr. Hua, and I don't hear that you disagree, there is no effective way of enforcing on an interim basis a dispute board decision, right? And I agree with that, because if you look at decision, the Circular 37, the dispute board procedure that is described there is largely a mediation type procedure. And if at the end of the process, the parties don't agree, and then life goes on. On the other hand, if you read some of the FIDIC contracts applicable to Vietnamese projects, you have a more robust procedure whereby, for example, once a dispute board decision is rendered, it is supposed to be binding unless and until it is modified by either a settlement agreement or by a final award. But that's all that the contract says. If one of the parties, the owner, does not comply with the dispute board decision, the contractor really has no effective recourse under Vietnamese law in Vietnam to enforce that dispute board decision. I mean, the only option is to start, as Chris suggested, one or many arbitrations to resolve the problem, right? So I guess then the question then becomes, okay, if you've got a situation where you have a government circular that describes a DB process pretty much as a settlement process, voluntary settlement process, and a FIDIC contract that describes it as something more robust or binding, how do you resolve the two? Is there a conflict, and is there a sufficient legal basis, Dr. Hua, to just say, okay, this is a FIDIC contract, this is a World Bank project, therefore it's a Treaty of Vietnam, and we just apply that, and never mind what Circular 37 say?
It's a quite difficult question for to answer, but I think first of all, it depends. First of all, to enforce a decision, I think it depends on the provision of the party, the stipulation of the party in the contract, to determine what is the intent of the party. And then I have to say that it depends on the good faith of one party, because even the contract can say that, because if we see the problem like a contractual issue, this become normal as other contractual issue. So it still need to have a arbitral tribunal or a court, for example, to enforce this decision. So because we don't have a cultural, like for example, FIDIC formal contract come from the originate from the common law. So in conjunction law of UK, they have a statutory DAB, and if the party want to bring their dispute to arbitration, first of all, they have to bring to DAB. This is different from something exist in Vietnam. So the culture is different. So the is this lead the difference in the conduct of the party. So I can give you a exactly result regarding this point. I just say that if there is a Vietnamese party, this still depends on a lot of good faith, and they have to try to go the arbitral tribunal to have a word about that.
Thank you, Dr. Wang. Chris, I have one last follow-up question for you on dispute boards.
Minh, sorry, could I just respond to what your previous question, or just comment on it, if I may?
Sure, please.
Please. And on Dr. Horst, and that is, and this is from an international perspective, obviously not from a Vietnamese perspective, but if you have an arbitration clause providing for the application, for example, of the Singapore rules or the ICC rules or the Stockholm rules, you now have a procedure under those rules for expedited arbitration. And indeed, I know Singapore is considering introducing an expedited procedure requiring that the procedure be conducted within 3 months. And the ICC, I know, is considering something like that. Now, the ICC's expedited procedure may last 6 months, but Stockholm has 3 months. Anyway, what I want to say is, now if you have dispute board decisions that are not being respected and you want them enforced promptly by arbitration, you are now seeing under international rules the possibility of getting a fast arbitration to enforce that decision. So I wanted to alert you to the existence of this remedy internationally. Thank you.
Thank you, Chris. My last question on dispute board is, I pick up on the statement you made that the World Bank requires and encourages and requires dispute boards to be set up for their projects. The complaint that I have heard is, why do we have to set up a standing board? Does that mean that the dispute board or the World Bank or somebody anticipates that there will be a string of disputes to be adjudicated by this board? And how will we find the money to fund on an ongoing basis this dispute board that may or may not be necessary at all? Third complaint that I've heard is, well, okay, so we all agree on these three guys, but they are experts in, say, delay. And all of a sudden, we've got a tax disputes on the other side. And are we stuck with this dispute board, the standing dispute board that we have appointed? So there is some discomfort in terms of the dispute board procedure being perhaps too cumbersome and more costly than it need be. And is that something you could comment on, Chris?
Yes, thank you. And that's a very good question, Minh. I think you might ask, well, why does the World Bank, why do the multilateral development banks, why do they require for major projects dispute boards? And they, of course, have had long experience of financing international projects, and they've seen numerous arbitrations under those projects. And they've come to the conclusion that it's going to be cheaper and more economical under major projects for disputes to be referred to a dispute board first, and not simply to international arbitration. In other words, they look, and I think this is the proper way to look at dispute boards and the cost of dispute boards. It's like an insurance policy. They have concluded that it is cheaper to pay the premiums, if you like, or insurance premiums represented by the cost of a dispute board, which is installed at the beginning of the project and remains in place throughout the project, than not having a dispute board and having only a provision for international arbitration, and then having very costly, lengthy, complicated arbitrations as occur under major construction projects, the cheaper solution is to provide for the dispute board. That is the conclusion after long experience of the major multilateral development banks. That is also the conclusion of FIDIC, which has also, of course, had a long experience under many projects and seen many disputes. So that is the reason. So I think the way to look at it, at the cost of a dispute board, it's like buying insurance. Why do you buy insurance? Well, sometimes you think it's going to be cheaper to pay the premiums than suffer the risk that is being insured against. And that's the reason for dispute boards being found now in major projects around the world. It's the result it reflects long experience. Now, obviously, you mentioned the qualifications of dispute board members. Obviously, you need to be very careful to select members who are going to have the right qualifications for the dispute. And that's something you need, but I think, so you mustn't dispute, select members who only have a narrow range of qualifications. It may be appropriate, for example, to have engineers, two engineers with different backgrounds, a civil engineer and a structural engineer or electrical engineer, whatever may be appropriate. And then for the third person to be, for example, a lawyer, to chair the tribunal. In other words, have a diverse membership. Now, on the question of the cost of dispute boards, I think major banks require, or some major banks, I know the Japanese Exim Bank requires that on projects they finance, that the cost of a dispute board be provided for as a provisional sum included in the budget of the employer for the project. So that is how that is dealt with. But I will stop there. Thank you, Minh.
Thank you, Chris. And now we move on to our third topic, which is limitations of liability in FIDIC contracts. And Nguyen, my partner Nguyen, will have the floor.
Hi, everyone. Limitation of liability. I love this clause. I think that it's often overlooked by a lot of the drafter, the contract or during negotiation, especially in the context of Vietnamese law. Why so? It's all about risk management. Why wouldn't you want to limit your liability? Obviously, it protects you. So oftentimes, the parties should pay attention to the enforceability issue of this particular clause and should pay attention during the drafting because it can save a particular party a lot of money if and when dispute arises. There are three components to this particular clause. The first component is limitation of liability or cap on liability. The second component is exclusion of certain liabilities. And the third component is exception to the rule itself or to the provision itself, meaning that in certain circumstances, you can break this limitation liability. And I will go through each of these components in the context of Vietnamese law in the view of enforceability. So the first component is limitation of liability or a liability cap. Under construction law of Vietnam, there's no provision on liability cap or limitation of liability. Construction law only provides in general that the breaching party must compensate for damages to the non-breaching party. And the damages should correspond to the losses suffered by the non-breaching party. It didn't say anything about the party can agree to limit or to cap on liability. So what happened? Well, fortunately, the definition of a construction contract under construction law provides that a construction contract is a civil contract. So we can look at the civil code. And the civil code in Article 13 as well as Article 360 provides that the non-breaching party can, or the breaching party should be liable to compensate for all damages caused to the non-breaching parties unless otherwise agreed. So that means that you can agree on a lower amount, i.e. the ability to agree on a cap. So on the issue enforceability, at least my view and as well as YKVN's view is that Vietnamese law will enforce, or this particular limitation of liability provision can be enforced under Vietnamese law. Moving on to the second component, which is exclusion of certain liabilities. The clause provides that neither party shall be liable to the other party for loss of use of any works, loss of profit, loss of any contract, or for any indirect or consequential losses or damage other than some certain subclauses of the contract. Now, there are two subcomponents to this. The first subcomponent is use of the works, loss of profit, loss of any contract. The second subcomponent is indirect or consequential loss or damage. Now, from a practical point of view, in terms of enforceability, you have to ask yourself, if the law doesn't provide for particular liabilities, whether you exclude it or not is irrelevant. If it doesn't exist or is not available, the party excluded away from the liability or not, make no difference. Under Vietnamese law, under the Civil Code, Article 361 provides for two kinds of damages, physical damages or spiritual damages. Physical damages include, among others, actual loss or reduction of income. So obviously for the first group of loss of profit, loss of any contract, loss of use of any works, that should be included in the category of physical damages. So obviously if the parties agree to exclude loss of profit, it's fine. With respect to the second subcategory of indirect or consequential loss of damage, well, under the commercial law, damages only include direct, either direct damages or direct loss of profit. Now, the Civil Code doesn't provide anything about direct, provides something about actual, but it's not about direct. So there can be an argument that, okay, maybe Vietnamese law, if you exclude commercial law, then it can open up to certain type of consequential damages, which is fine. The party are free to exclude it from liabilities. Now, the last component, which I think is very important, is the exception to this provision itself. And on this component, FIDIC contract provides that this subclause shall not limit liability in any case of fraud, deliberate default, or reckless misconduct. Now, the Red Book 2017 added gross negligence by the defaulting party. I have a personal experience on this particular sub-provision or component because I was invited to be the co-chief editor for the Red Book 2017, as well as some other book of this suite. And when I was trying to, well, the task force was assigned the task of translating from English into Vietnamese and produce this bilingual version of the book. And we had a lot of argument among the task force because there's no equivalent of Vietnamese wordings or terms for certain concept that might be available under common law, but not in Vietnam. Fraud is easy because fraud can be found, or the definition of fraud can be found either under the civil code or the criminal code. But we don't have the concept of deliberate default. We don't have the concept of reckless misconduct. We don't have the concept of gross negligence. So what will happen if a party trying to break or try to argue that the other party cannot claim limitation of liability because they have acted either in a manner of deliberate default or reckless misconduct or gross negligence? It would be difficult if it doesn't provide under Vietnamese law. The recommendation that I would give to my clients is that they should modify this particular provision to fit within the Vietnamese law context. And under Vietnamese law, under the civil code, there's only the concept of fault, either intentional fault or unintentional fault. So it would be best for the party to negotiate and then decide whether or not they want to use either intentional fault or well, obviously you don't want to put an unintentional fault, but whether they want to use intentional fault to replace the concept of deliberate default or reckless misconduct or gross negligence. Or I think in Chris' book, he suggests that maybe it's better for the party to provide definition. If they still want to stick with these particular terms, then you should define it. And perhaps you can convince either the court or the tribunal to apply the definition of this term to resolve the dispute. And I would agree with Chris. I think it's very important for the parties to negotiate and to modify this particular issue so that if and when a dispute happens and relate to the limitation of liability, you don't have any issue on enforceability of this particular subclause under either the Red Book 99, Red Book 2017, or any other book. That would conclude my my presentation. Chris, do you have any comment on this?
Yes, thank you very much. Let me just point out that if you go back and look at the first editions of the Red Book, which that's to say until 1999, there were about 3 editions before 1999. The Red Book was prepared by a different drafting committee from the one that prepared the Yellow Book, that is the book under which the contractor not just builds the work, as is true under the Red Book, but designs the work. When the contractor both designs the work and builds the work, that's the Yellow Book, where the contractor simply builds the work, but in accordance with the employer's design. That's the Red Book. Now, until the 1990s, only the Yellow Book, that is to say the book that provides the contractor designs and builds the work, only that contained a limitation of liability clause. The Red Book had never contained one. Now, in 1999, and because until 1999, each of the 2 forms of contract were being prepared by different committees, different working groups, the different forms were inconsistent even on matters that were common to both forms. And FIDIC thought, well, this is not a good idea. We ought to be consistent across our forms of contract. And therefore, in 1999, there was a single committee which drafted the 1999 books, the Yellow Book and the Red Book, as well as the Silver Book. And we harmonized across all the contracts. And as a result of that harmonization, you have a limitation of liability clause in the Red Book that you didn't have before that. And I don't think it's that important in the Red Book. It is important in a contract where the contractor is doing the design, because then the contractor takes fitness for purpose responsibility for the works. It becomes finally responsible for the works, possibly for 10 or years or longer afterwards, if anything should happen to them. Whereas the Red Book contractor doesn't have that responsibility. Once the works are completed and once the guarantee period has expired, frankly, it doesn't see much exposure to risk. Now, on the question of under Vietnamese law, there is no concept of gross negligence. The only comment I would make is Vietnamese law is quite isolated if you look at the position around the world. If you look at in France, there is a concept of gross negligence. In the United States, there is a concept of gross negligence. And in the Arab world also, which is also largely civil law, you have a concept of gross negligence. England is the only other country where gross negligence there hasn't been that concept and has caused them difficulty. But as you say, the practical solution is define gross negligence in the contract, so that because that is likely to be the best solution.
Nguyen, do you have anything else? Thank you, Chris. I think we're now ready to move to the fun and exciting part of the program, which is questions and answers. We have almost a full attendance in the room today, so I would invite people who have questions to. There's a question.
Thank you so much. Very interesting discussion between you and I learned a lot from all the solution made by you in adapting the FIDIC contract in Vietnam. I have a comment and also a question about the dispute board. In Vietnam, Ms. Hoa have said about the possible way of enforcement of DB decision by arbitration. But I'd like to add something on mediation, because if we read the text of the decree 37, so Article 45 of this decree stipulate that and call the DB as mediation process. So the question is, sometimes for us it's difficult to define the nature of the DB, because in Vietnam we have ADR include negotiation, mediation, and arbitration. No DB, no other ADR mechanism except in the contract, in construction contract. So maybe some people think that it's mediation. So my question here is concern the worry of Ms. Hoa and everybody of the question of enforcement. If we can do DB in Vietnam and we can do it in according to mediation principle, we can enforce the DB decision by like we enforce a mediation settlement agreement in Vietnam, because now we have in our civil procedure civil code and in the decree 2022 the mechanism of enforcement of mediation agreement. And in international approach, we also have Singapore Convention. So my question is like that, for Chris and for the experts, if in Vietnam we have DB expert, DB members, 3 members, and these 3 members resolve the dispute between the parties in the way like a mediator. So in that case, can we consider that the DB decision have the value, the nature of a settlement mediation settlement agreement or not? Is that clear, my question?
I will answer
Yes,
before and
thank you.
looking to have having comment from Chris. To be honest, it's an interesting view, and I have published an article on that on American Journal regarding the determine what will be the exactly nature of dispute adjudication decision. And I also study the history of arbitration to find a best solution. Is, from my view, is possible. It's possible if we want to support DB decision or DB procedure. We can see it as mediation procedure. Just there is one point regarding FIDIC form of contract. I have hesitation that because according to FIDIC form of contract, the parties still want to bring DB decision to arbitration subsequently, even they have to execute it. So because why is the reason? I have a personal view that this typical DB or DB decision is given by engineer who is not legal expert. So regarding to the justice, we are learning that it is necessary to have something we call justice. So possible people, and also as something Chris has said, that the concept of DAB is originate from the theory that pay in advance and discuss after to protect the contractor to be paid by the employer. So if we consider DB decision as mediation, this will be risk that in case that disagreement of one party does not notify in the limit period according to the contract, they don't have the opportunity to bring the dispute to second mechanism like court or arbitration procedure. This is just one point of view that I have a hesitation on this point, but theoretically we can see compare with the history of DAB and history of arbitration. We should, from my point of view, we should see DB as mediation procedure. I think this could be a way to develop this procedure in Vietnam. So I don't know if Chris or anyone other expert can give other point of view or not.
Good. Yeah.
Chris?
Yeah. Thank you, Minh. I can't. I think that's a very interesting question, a very interesting proposal to try and consider a dispute board decision to be really the result of a settlement pursuant to a mediation. But I can't comment on, obviously, on Vietnamese law. But what I would like to draw to everyone's attention is the fact that today the emphasis as regards dispute boards is no longer on dispute board making a decision or on dispute resolution. It is on dispute avoidance. And that is to say, to avoid any need for there having to be any decision by the dispute board. And the members of dispute boards now, and I think this is the right way to approach it. When you're coming to select members of dispute boards, you want to select people who are going to be able to assist the parties in avoiding disputes and taking the initiative in assisting the parties to avoid disputes. In other words, who come regularly to the site every couple of months or whenever some particular issue arises on the site, and who meet with the parties and seek out what issues are there between them and work with the parties, assist them in a kind of mediation rule. That's exactly what we're talking about, to avoid the need for any dispute to have to be referred to the board for a decision. That there is now a special clause, subclause in clause 21 of the FIDIC 2017 contracts describing dispute avoidance. And that is really where dispute boards are going today, and away from dispute board decisions. And I think the best dispute board members today are very good at assisting the parties at dispute avoidance and avoiding the need for there ever to have to be a request for a decision on a dispute. So it is absolutely in the direction of mediation that dispute boards are going today.
On this issue, and I'm sure that Nguyen Minh Dung will have some comment on this. But before that, I have slight different view from Dr. Hoa. I think there's a gap between Decree 37 and Decree 22, and it's quite dangerous. And the gap here is, it appears that under Decree 37, DB process is considered as a mediation process. And I don't know why. Perhaps because under the construction law, there's only mediation or arbitration or court proceeding to resolve a dispute. Now, Decree 22 on commercial mediation, there's a gap, because if you follow Decree 22, there's certain procedure and requirement. And certain requirement would actually prevent the party to have a DB process in accordance with sort of international standard. And I'm reading Article 12 of Decree 22. It requires that you have to select a commercial mediator from the list of commercial mediators of a commercial mediation institution, or from the list of ad hoc commercial mediators published by the provincial level Department of Justice in Vietnam. So there will be a risk that you cannot appoint any DB member outside of this available list. Also, at the end of the mediation process, you need to get an agreement from the party, and the party have to sign a mediation agreement. And I don't think that a DB process works in the same way as mediation. So my view is that we should consider DB process different from a mediation process. I don't think it's the same, and I hope that Decree 37 of 2015 can be amended to clarify on this point.
Yes.
I'm sure Dr. Hoa is a DAB expert, but I am an ADR or mediation expert. Why? Because I study ADR and mediation at Queen Mary University of London in 2007, 2008. And when I back to Vietnam, I was a member of the drafting committee of the Decree 22, together with Ministry of Justice. The drafting of the Decree 22 were initiated by a STAR project of US. STAR project encouraged the Ministry of Justice to regulate the operation of ADR in Vietnam, right? So we start drafting the first draft in 2012. And the first idea is to regulate not only mediation, we wanted to regulate mediation, DAB, DocDec, expert determination, and any other form of ADR. However, after the quite long time consideration internally between the Ministry of Justice, they told me that it's not workable because when we consult with other branch of the government, no one knows what is DAB. And in 2012, it is extremely difficult to persuade the people that there is a different kind of the dispute resolution as mediation. Then the Ministry of Justice said that if we try to cover other form of ADR, the draft never become true, the government approval. So narrow down the scope of the application of the regulation, just focus on commercial mediation. That was the reason why Decree 22 started from 2012, but only effective in 2017. And no gap here. Decree 22 in 2017 replaced the definition of mediation, because before Decree 22, there's no any legal regulation about mediation. What is mediation, right? So now I don't think Decree 37 about DABE mediation is now valid, because the mediation will be defined and regulated by the Decree 22. Adjudicator is not licensed mediator. If you want to be a licensed mediator, you have to apply to the mediation center in Vietnam, like VICMC of Dr. Hang or VMC of the IEC, or you have to register with the local Department of Justice to become an ad hoc mediator. Mr. Thanh here is also ad hoc mediator, right? So no question about the DAB is a mediation anymore. So what is DAB? I was lucky to be a member together with Mr. Nam Trung here in the ICC Task Force on Arbitration and ADR. And we just complete our task last year in ICC. And ICC issues a new guidance on how to use the ADR in different forms, including DAB, as a mechanism to manage the risk and to prevent the dispute. So DAB no longer to be just a method of dispute settlement. DAB now is a corporate mechanism, governance mechanism to help the enterprise to manage the risk and to manage to prevent the dispute. So I insist the enterprise here to set up standing DAB from the beginning of the project, not wait until the project has a dispute, right? So the next question, as you mentioned, that about enforceability of the DAB finding, right? That is a question. When we first discussed internally between Ministry of Justice, we all agree that both DAB and mediation has the same feature, that the outcome of the mediation process or DAB process should be considered as a new contract. And it should be enforceability under the Civil Code of Vietnam as a new contract. If there is any dispute about someone dissatisfied with that contract, new contract, and don't want to enforce that new contract, the other party can bring that to the arbitration or to the court, not to open the dispute or the whole thing, but just consider the legal right and obligation set down under the DAB finding or mediation settlement agreement. But you will not see the legal concept in the Decree 22, because they said that if we make it very clear that settlement mediation is a new contract, it's a little bit difficult for the court to adopt. So just simply say that the outcome of mediation is under, it should be settled under the Civil Code. And then the court support it by create the chapter 33 to enforce the settlement, mediated settlement agreement under Decree 22. So you have two ways to do that. First thing, as Dr. Hang suggested, that if the DAB finding is not enforceable. Party can go one way to the medicine center, like Dr. Hang said, and then try to make that as a mandated settlement agreement. But it will be difficult, right? Because you have to negotiate again. But the other way is that you had framework the DAB finding as a new arbitration agreement, in which you narrow down the scope of the dispute. That party now no longer dispute on the underlying contract. Now they dispute about the enforceability of the DAB finding. And I were in the case, the tribunal agree with that approach. They said that if the party have no dispute about the underlying contract, they only dispute about the final finding of the DAB about specific item. The arbitration tribunal should have limited power to review only the disputed issue under the DAB finding. And the other case I have is one party claims the other party that under the contract, you have to proceed the DAB, but you didn't. So it breached the contract, and now I claim you for damage arising from that breach of the contract. And majority of the tribunal, I said, agree with that approach. The problem only, how can you prove the damage caused by that kind of breach? Because liquidated damage is not enforceable here, as Mr. Nguyen can say. So that is the only thing I think I can say. Thank you.
Thank you so much for your point of view and your comment on my idea. I just share and explain why as I have said that theoretically, we can consider DAB as a mediation, and why and in my article I also explain why I have this view, because actually we have Singapore Convention on Mediation. So this is the way. Imagine DAB not only will be enforced in Vietnam, but maybe enforced at international level. In that case, what will be the instrument to support this decision? For example, DAB in Vietnam say that a contractor in Singapore have to pay for other subcontractor, for example. So in that case, we don't have an international instrument to support this. This is the reason why I just propose that as the Americans often say that if you want, you can. So what is your purpose? For example, in Vietnam, first of all, you can your part of it is the possible useful for practitioner in Vietnam, but something I see is in international level, because I want to develop this procedure at international level, not only in construction sector, but other technical issues, for example, in car production or computer production, for example, on the sector, the main technical expert like the engineer. So this is the reason why, and I think Singapore Convention would be a suitable choice to support. This is the reason why I share my part with that. But in practically in Vietnam, so we have to try, and also I think all the solution people can think about that is under Vietnamese law, arbitral tribunal can give a provisional emergency order for payment. So the best solution for a foreign investor is that they should try Vietnamese arbitration center. In this case, the order of arbitral tribunal can be supported by executed authority, Vietnamese execution authority. So I think this could be a solution too for those who want to use freely form contract in Vietnam. And at the moment and in the future, it's good. It's true that we can learn from UK mechanism. In that case, the UK don't talk about what does it mean DAB, what is the nature of DAB procedure. They just say that if there is any dispute, the party have to immediately bring the dispute to DAB. And if the party don't respect this pre-arbitration procedure, then the arbitral tribunal have to stay to so that the party follow the pre-arbitration procedure like DAB. So they don't recognize what does it mean or what is the nature of DAB. I think this is a good way if we want to learn this mechanism. This is some comment from my side.
Minh, if I could add something?
Yes, please. I was going to call on you.
Thank you very much. Thank you very much. Let me just say, for the benefit of everyone in the room, you know, the dispute board was introduced into the FIDIC contracts in the late 1990s. We've now had nearly 25 years experience of dispute boards. I think what people should know, if they're not already aware of it, is dispute boards have been a fantastic success around the world. I mean, there's been an explosion of dispute boards and they are growing, they're expanding. Not every country has adopted them, taken them on board. They're more popular in some countries than others, but there is no question that dispute board, there's no doubt today, and no serious question that dispute boards are the way to go. They are the dispute resolution procedure of choice in international construction contracts. I don't think anyone would seriously dispute that today. There may be people, but I think there's such a large consensus around the world about dispute boards. So I want people to be aware of that. Secondly, yes, dispute boards, as in the case in Vietnam, there has been difficulty in civil law countries in knowing and determining how to analyze a dispute board. What is it? And it's given rise to the issues that we've just heard about in Vietnam, in other countries, in other civil law countries. And what they have done, and it's notable that 5 countries, Brazil, Honduras, Indonesia, Italy, and Peru, all civil law countries, they have all agreed that dispute board is a great idea, and they have introduced special legislation governing the dispute board. So it is clear under the legal systems of these civil law countries of exactly what a dispute board is and how it operates. Anyway, that may be something you might want to be considering in Vietnam. That's all I have to say.
Hello, Chris. Yet we really consider that the role of the Society of Construction Law Vietnam. We learned a lot from Indonesian friends. In 2017, they add dispute board into their construction law together with the mediation, arbitration, and litigation. They add dispute boards. And by 2020, they have the decree on the mechanism and operation of the dispute board. And you know that the huge decree, the number of arbitration case on construction arbitration case from Indonesia in maybe RIAC have been dropped. And also a lot of dispute in Bali also going down because the party are using dispute board to solve the problem prior to going to the dispute to arbitration or litigation. So from us, we also want to, to change the construction law of Vietnam to dispute board so that the mechanism is more clear, is being set for the other one. For your information, in Decree 37, why it has the dispute board is a type of mediation. Why? Because at that time, the construction law they know only mediation, arbitration, and litigation. So they have no way. Decree is under the law. So they have to adopt that term. Only when we change the construction law, then we can open the door for the development of dispute board in Vietnam, especially for the the project that involve the state out fund, the state fund. That's my 2 cents.
Thank you. Chris, do you have something to add?
No, I think what Trung has said is very interesting. Yes, maybe what you need to do in Vietnam is explore whether you should be introducing a law governing dispute boards. In that case, that you have precedent in all these other countries, Indonesia and the other countries I've mentioned.
Yes, I'd like to add one thing. Why I raised this question, because it's really the practical difficulty of parties. They come to my mediation center and said that yes, we have DB in our contract, but we are worried about the enforcement. And really we try to find the solution in Vietnam now. Because we cannot wait for change of construction law. We have to act now. So we must have some kind of solution. And for the comments of Mr. Khoi, I agree with you. Some technical difference between mediation and the DB, but we can, with the agreement of the parties, freedom of contract, we can correct it. And now I'd like to say to you that some cases have been done by that way, by that solution. Because if we can go to arbitration like the solution made by Mr. Trung, but there are risks and costs, also costs. Yeah. So it's the reason why. And I totally agree with you that they are mediation and DB must be two distinct, two different mechanisms. But in our case in Vietnam, we try to do something better with the current legislation. So thank you so much for all the discussion. Very interesting. Yeah. Thank you.
Thank you, Dr. Ham. Very interesting discussion. I think we probably have time for one last question for Chris. Chris, the last question is yours.
Okay.
Thank you for this. So my question is with respect to EPC contractor and with respect to variation. Oftentimes the EPC contractor, my clients come to me and say, what happens in case of variation? Do I have a right of refusal? Because the contracts, the way they are drafted, are very pro-owner or pro-buyer. What can a EPC contractor, how as we as draftsmen, as lawyers, can add clauses or perhaps tweak clauses that make it more friendly for the EPC contractor? And can we include a right of refusal on behalf of the EPC contractor for a variation which they feel that, okay, it's very difficult for them, or maybe it exponentially increases the contractual price?
Yeah, thank you. If that question is for me, thank you very much. FIDIC contracts provide in the Silver Book in particular, but also to some extent in the Yellow Book, these are similar to EPC contracts, and they provide, they include a variation clause. So there's no difficulty, at least under those standard forms, for there to be variations of EPC contracts. On the other hand, it's well accepted certainly in FIDIC contracts, but I think in the general law, that variations must be of a limited nature. They must relate to the character of the works that are being constructed, the main works being constructed, and they need to be reasonable in extent or amount. So they need to be variations, not basic changes in the works, and that is provided for in FIDIC contracts, and indeed in FIDIC contracts the contractor does have, you need to look at them, but the contractor has the right to object to certain variation instructions. For example, if the contractor considers that that if the variation is introduced, that will affect the contractor's fitness for purpose obligation under an EPC contract, for example, or obviously if the variation is for important works which are unrelated to the contract, and also I think if the contractor does not have the basic resources on site or accessible to it to implement the variation, then the contractor can object. So there are provisions to that, limiting the employer's right to require variations under EPC contracts in the FIDIC standard forms, which you could look at. And then the question comes up, well, how do you price the variation? That can be a bit tricky under an EPC contract. One solution I've seen, this is not the FIDIC solution, but the FIDIC has its own solution, is this is done on a kind of an open book basis. The contractor basically produces its accounts and shows what the cost of the variation has been, and then is entitled to some fixed markup for overhead and profit, something like that. But in other words, an open book approach to pricing variations under EPC contracts.
Thank you.
Okay, I think with that, we're ready to close the program. Before I do, Chris, I want to make sure you knew that Dr. Hang is a law school dean or vice dean. Mr. Trung, who spoke from the back, is one of the country's top arbitration practitioner. And so today, what we have seen in this room is a policy debate involving some of the best legal minds in the country on the subject of dispute board. And we have also seen the way in which your experience, Chris, has contributed meaningfully to this debate. So let me close by saying that today I'm even more convinced than I was in Singapore that we all need Chris's book, and for the right situation and case, we will all need his advice. And I want to thank everyone for taking the time on a Friday before a long holiday week to come and attend this event. Thank you again, Mr. Trung, for co-hosting this with us, Dr. Wah, Mr. Nguyen. Thank you, Chris. Last announcement, there will be a no-host bar networking drink immediately after this session at the rooftop bar of this hotel, which is one of the better-known locations in this city. So if you have time, please come join us. And if you have questions or issues about DAB that still have not been answered, please bring them. With that, thank you very much, and thank you, Chris.
Minh, if I could just say, I've been tremendously impressed with the questions and the enthusiasm of everyone in the room. Thank you so much. It's very stimulating for me, and thank you, Minh, for organizing this wonderful conference. Thank you.
Sorry, I want to add 2 cents. We have received some book from Wolters Kluwer. Yeah, free book that we would like to given to the University of Law and to YKVN at the, for this book launch. And also, please remind us, there is the discount cost for purchase the book until May 5. Please, you can use that one for your purchasing online directly to your place. Thank you. Yeah.